these are, some people would say these are difficult times for those of us who work with refugees. If you recall the last election overview in Canada, we saw images of people on boats, and the government message, these are terrorists and they have to get tough, and the opposition parties are soft, and that's why you have to vote for the Conservatives. We now have seen legislation that's about to pass Parliament that's going to impose harsh measures, mandatory detention, denial of the right to get permanent residence for 5 years. We now see this as coupled with other measures, administrative measures, denying access to medical care for refugees who are designated, and at the same time, even reducing the access to medical care for all refugee claimants, to the point that the medical profession is up in arms and is mobilizing against these changes. So in this context, it's easy to feel a sense of despair. And that's why I think it's important for us to take a long view. And that's why I thought the contribution I might make would be, given I have a history in the refugee business for the last 30 years, was to take a long view and to reflect on the history of the refugee determination process in Canada over the last 30 years. Because I think when you do, we can see that this moment is but one moment in history. And it's really a pattern of waves, of high moments and low moments, and this may well be, and certainly many would characterize it as a low moment. But it's just one moment in history. In a history that's still being written and will be written with the work of all of us in this room who care deeply and passionately about refugee and refugee rights. Second hypothesis I want to put out is that when the legislative and the executive go too far, the courts push back. We've seen this over the years, and we saw it, for example, with Cherkawi 1 and Cherkawi 2. We saw it with cases like Abdul Rezik, the Canadian citizen who was stuck in Sudan because the Canadian government wouldn't issue him a passport. We saw it with the decisions of the courts in Qatar, and now hopefully we will see it again with the Supreme Court consideration of cases like Aguilera and Escola. And the third point I want to make, and I think this is the most important one, is there's always been a constant. In all the years that I've been working in the area of refugee law, I have always found that there are many committed, intelligent, and dedicated people who work and will continue to work tirelessly to defend the rights of refugees. So when you consider the reality from this perspective, you see that this is just one moment, and a moment which will pass and will be superseded by other more positive moments. So I'd like to go back in time to when I first started, and sometimes when I reflect, I can't believe this is long ago as it has been, because it seems like only a moment. When I was here at Osgoode Hall, actually, studying, and got involved with CLASP and all the other legal aid clinics at the time. We're talking about 1974. In 1974, there wasn't a refugee determination process in Canada at all. And the view of the authorities was, well, Canada isn't the country of asylum because we don't have any refugee-producing countries on our borders. We're a country of resettlement. We brought in Hungarian refugees, Ugandan, and so there wasn't really a process. There was one provision in the Immigration Appeal Act that allowed for persons who had been ordered deported to make a written application for an oral hearing alleging that they might be victims of discrimination or persecution. Most of the people who applied were rejected, and the vast majority of them were ship jumpers, most of them from Eastern Europe. But something happened in South America in 1973, and for those of you who remember that far back in history, we're talking about the coup d'etat in Chile that saw the elected government of Salvador Allende overthrown and a brutal military dictatorship, Pinochet, installed in power. Geography brought in a direct air flight from Santiago to Toronto. And many of you remember the defunct Canadian Pacific Airlines had the route at that time. And so as people were arrested, detained, and tortured, and then released, some of them got on planes and ended up in Canada. So in 1974, we saw for the first time the arrival of spontaneous refugee claimants in not large numbers, but more than Canada had been accustomed to. And so at that time, the government was confronted with, well, what are we going to do and how are we going to process these cases? And so they created an extra administrative process where refugee claimants who spontaneously made claims at the border would be examined under oath by an immigration officer. And they anticipated there wouldn't be that many claims, so they would conduct these hearings, a transcript would be prepared. The immigration officer had no expertise, he would just ask a bunch of prepared questions. A counsel could be present, so we could prepare the person, try and assist them in getting out the relevant details. It was then sent to the special interdepartmental committee in Ottawa, and they would make a recommendation to the minister, and if they recommended positively, the minister agreed, the person would be given a special permit and would be processed for permanent residence in Canada. So that was the process that was invented. It was not in the legislation, and this process was in effect from about 1974 until the law was changed in 1978. Remember, in 1974, there was no legal aid for refugees. And can you believe it? There was no internet. There was no online jurisprudence. There wasn't really any jurisprudence on refugee law. I think the only book that we had was some of the international law texts at the time on the meaning of refugee definition. So, you know, there is very limited information available on what's happening in the countries. Although, you know, Amnesty was, I think, publishing reports back then. But that was pretty much it. The Department of State reports didn't exist. And you couldn't go online and type in, you know, Chile and human rights and get like 1,000 articles. So people would tell their stories of torture. And at the time, I remember many of the claimants who came off the plane had just been released from prison days or weeks before. And I remember seeing people come off the planes and they would say I was tortured, and I would say, well, how? And they would explain that they were given electric shock. And then they would actually show me the burn marks that were still present. And any of you who know about torture and electric shock, which is unfortunately one of the things I've learned over the years, is that usually if people are severely tortured, those marks are present, but they usually fade away. They're not permanent, they fade away after 3 or 4 weeks. So people who showed up with these marks on their body, we had to get them to a doctor quickly, get the pictures taken, photographs, so that we could prove that they had the telltale signs of having been tortured. And of course, this created a whole new world of doctors who all of a sudden who knew nothing, because, you know, fortunately, there isn't a practice of torture in Canada, so doctors in Canada had no idea, and they did all this research. There apparently were some doctors in Denmark who studied the effects of torture, and they were able to prove that these red marks on people's bodies were usually signs of electric shock. So we created this whole new expertise in Canada of doctors who would be able to write letters corroborating the existence of torture. And of course, then we got psychiatrists involved, and they would write psychological reports saying that the people had post-traumatic stress. So there were compelling moments for those of us. I was also a student at the time. I had never been to the third world, didn't know anything about Chile, had to learn, had to understand the crew, the political realities. There was huge challenges because, as I said, we didn't have information, but we forged ahead, and many of our clients were accepted. Every now and then I run into the son or daughter of one of my claimants from those days, and they recognize me and thank me for helping bring their family to Canada all these years later. After that, of course, you know, the dictatorships from Chile, there was Uruguay, Argentina, and Guatemala, El Salvador. And of course, you know, as the number of claimants increased, the government introduced the visitor's visa as a mechanism of trying to stem the tide of refugee claims. And so we saw the visitor's visa from Chile. In 1976, the government introduced the Immigration Act, And they put into law this procedure, this examination under oath, and if you were rejected, you had a right to apply in writing to the Immigration Appeal Board. And this, we begin to see one of the refrains that will repeat itself, because I was part of a coalition, and Tom Clark was there. I think he was part of the same coalition back then, and there may be others in the room. I don't know. I'm telling you, we're revealing our age. And we told the government at the time that this process wouldn't work. It was too convoluted, it took too long, you can't just have a hearing and send it to someone in Ottawa. It wasn't fair because the committees were making credibility findings based on plausibility and based upon credibility without actually seeing the person and without being really able to assess their credibility. So we said it was an unfair process and it was also too convoluted. The warnings of the refugee advocates were ignored, of course, and so this new process was introduced: examination under oath, Refugee Status Advisory Committee, recommendation to minister. If you're accepted, you get your status. If not, then you had a written appeal to the Immigration Appeal Board. So what happened? Well, in the 80s, all hell broke loose in India. There was the problems in the Punjab, the attack on the Golden Temple, and there were large numbers of Sikh refugee claimants. Some of them were genuine, and some of them were economic migrants, people fleeing the civil unrest and looking for a better life. At the time, the government portrayed these as bogus refugee claimants. And it's interesting, because the truth was that maybe some of them were bogus, but there were really some who had really been victims of horrible persecution in India. And the documentary record of what happened in the Punjab in 1994 with thousands of young Sikhs being killed and many others being tortured is a testimony to that. But as always, the response of the government was to describe these claimants as bogus. But what happened, of course, was that the system became hopelessly bogged down. As we warned them, it just took too long for cases to be determined if they had to be interviewed and sent to another committee, and another committee would meet, make a recommendation, go to the minister. And so the backlog started growing and growing and growing. At the same time, refugee advocates were concerned because the system wasn't fair, because they were making credibility findings based upon a review of a transcript without actually allowing the person to be heard. And actually having someone who made the decision see the person look him in his eyes and say, yes, I believe you, and I don't. As the backlog grew, there became an incentive for people who weren't genuine refugees to make claims. So people who wanted to stay for economic reasons, they knew that if they made a claim, they could get 2 or 3 years in Canada with a work permit, and then the uncertainty as to what might happen afterwards, and they might be able to stay indefinitely, encouraged a lot of people who didn't really have a fear of persecution to make claims. So the backlog grew even greater. And then, of course, the other warning that we had given to the government, that this was an unfair process, came to bite back, because in 1985, the Supreme Court of Canada gave us the Singh decision. And the Singh decision, of course, says that you can't make credibility findings without an oral hearing. So given the backlog in the Singh decision, the system was in a state of total disarray and collapse. Unfortunately, the government couldn't think of anything better to do than in 1986 to announce that they were going to reform the legislation and give an effective amnesty to the people in the backlog. But they didn't bring in the reforms. So lo and behold, what happened was they waited 3 years to bring in the legislation. And in that 3-year period, a new backlog was created by people who speculated that when the reforms were finally brought in, there would be a new amnesty. So there had been a backlog, I think, of about 20,000 claims. Between 1986 and the amendments in 1989, the backlog grew to more than 100,000. During the period 86 to 88, refugee advocates met with members of the government to try and help design a new system that would be fair and efficient. Some of you may remember Jim Hawkes. He was the chair of the Citizenship and Immigration Committee at Parliament. And some of you may know that at one point, one of his parliamentary assistants was a young man by the name of Stephen Harper. So Jim Hawkes convened meetings after meetings, and we tried to convince the government to create a model that would be fair and efficient. In 1989, the government introduced the reforms that led to the creation of the Immigration and Refugee Board. Still, even at that time, there was what we would call, I would call schizophrenia in the government, because although by now it was clear that people were coming to Canada, making their way to Canada in different ways and claiming and seeking asylum here, and because we were signatories to the Refugee Convention, we had a duty and an obligation, both under international law and under the Charter, to assess their claims, because we couldn't send them back to face persecution or torture unless we were sure that they were not at risk. Senior officials in the government would continue to maintain that Canada is not a country of asylum. I was at a meeting here at Osgoode Hall in 1988 when we were debating the reforms with Ralph Gerard, who was at the time the Director of Refugee Policy. Meeting I remember well because I was on a panel, and someone asked Mr. Gerard, what could you do to fix the refugee system? And Mr. Gerard, Osgoode Hall Law School, looked at the audience and said, I'm going to quote Shakespeare. And he said, to quote Shakespeare, kill the lawyers. We were the people that were to blame because we were asserting the rights of our clients, and that was what was causing the problem. In any event, the government brought in the Immigration and Refugee Board and brought in two other measures. The Safe Third Country measure, which would allow them to turn people back at the border if they had an agreement with the United States, and the Credible Basis Tribunal, which was a screening mechanism that would allow them to deny access to a full hearing to claimants whose claims were not found to not be credible. When the bill was debated, we again warned the government. We told them that the process was too cumbersome. We said that if there was going to be a credible basis hearing, that any lawyer would be forced to present the entire case because they could not risk having their client's claim denied based on a lack of credible basis, so that they were creating, in essence, a two-stage process, one to get as a screen and another to have the full hearing, and that it was a huge waste of time and energy and would bring the system to a halt. At the last minute, the government accepted an amendment which we urged upon them, which allowed the minister to agree that there would be a credible basis, in which case that agreement was binding on the member, because we told them that even if the minister stands up and says to the tribunal, we agree there's a credible basis, if that determination is not binding, we can't be sure that the member is going to accept it. The tribunal is master of its own decisions, and they could say, well, that's fine that you say that, but I don't agree with you, I want to hear evidence. That amendment saved the system from total collapse for a period of time, because otherwise the system wouldn't have lasted a year. When the bill was implemented, I saw after the bill was implemented a briefing note that was prepared by the same Ralph Gerard, and he estimated that there would be 18,000 claims in the first year, that 6,000 would be screened out through the credible basis, 6,000 would not get a claim at all because they would be turned back to the border based on third country, and so they projected 6,000 claims for the Immigration and Refugee Board in the first year. Well, guess what happened? Now, the people here probably know the history, remember the numbers better than I do, but I vaguely remember that the total number of claims in the first year was well over 25,000. Of course, the United States didn't agree to the third country agreement until after 9/11, when they did for other reasons. So those 6,000 claims that they thought that would be eliminated based on the third country agreement didn't happen. And the credible basis screening process, which was supposed to eliminate 1/3 of the claims, didn't even eliminate 5%. So lo and behold, the IRB, which was projected to have to handle 6,000 claims, was forced to handle over 20,000 claims in the first year. So it was on the verge of collapse before it even started. Second example, or the third, of how we warned the government that their proposed reforms would not work, and we were ignored, and we were proven right. I suppose the period after 1989, when we look back, it was probably a positive time frame. There were certainly issues. We had issues, and we have always had issues about political appointees at the board, the lack of appeal, and of the refugee determination. But of course, there was still a high rate of acceptance. We had oral hearings, and during the period we had the court, some very positive decisions of the court. We had Ward, and then as later on we had Surish, Chakari 1, Chakari 2, and Katter, which are all relevant. The credible basis was eliminated in the 90s because, as we predicted, it was a useless step in the process. And we also saw other things happening. Because the government didn't have sufficient resources to effect removals, and the situation in countries would change over time. So refugee claimants would, from, for example, Sri Lanka, who would be rejected in 1990 because there was a period of peace and calm and there were peace negotiations. When they were removed in 1992, the Civil War had started up again and people were at grave risk. So we would go to court and we would file applications, humanitarian applications, and seek stays from the judge and say, look, this determination that was made in 1990 is no longer valid because it was made at a time of peace and now there's fighting and our clients are in danger. Someone has to assess this. And we would get stays routinely. So, of course, this whole process led to new reforms and the implementation of the Immigration and Refugee Protection Act in 2002. And taking into account these problems with delays in removals, the government introduced something called the pre-removal risk assessment, which required that there be a risk assessment just before removal. The government also made some positive changes. They introduced Section 97, which allowed for persons to make claims also based on risk of torture, cruel, inhumane, and degrading treatment. The government introduced an appeal that we had fought for, but didn't proclaim it. Of course, there were still issues of the competency of board members and the lack of an appeal, as I said. But the system was certainly functioning well, with some problems in some cases and some issues with respect to appointments, but at least we had a reasonably fair system. Of course, then the two boats arrived, and that was a whole other experience for us. The boat arrived, the first boat arrived, and the government response was fairly muted. But when the second boat arrived, we got, even before the boat was arriving, they knew it was coming, the anti-immigrant rhetoric. These are terrorists, we were told, and these are people, and the people smugglers are involved, and this poses a grave danger to Canada. The claimants arrived, and of course, the Sun Sea migrants especially were treated in the most unbelievably shameful fashion by Canadian Border Services Agency. I represent a large number of the claimants, and I can tell you that as a Canadian, I'm profoundly shocked as to the way they were treated. They were subjected to abusive interrogations by CBSA officers. One of my clients came to Canada with his young son. He was separated from his son. During the course of the interrogations, the officer threatened. He said, "We know you're LTTE." My client isn't, and they never were able to prove he was. "We know you're LTTE. Others have told us you are. Others have told us your son knows you're LTTE. So if you don't admit it, we're going to interrogate your 6-year-old son." They would call him in at another time and said, "We spoke to your wife. She told us you're LTTE. All you have to do is admit it." They called the wife and said, "We have your son and husband, and we're going to deport them unless you admit to us that your husband's LTTE." This type of abuse was commonplace. The government called them all bogus claimants and used their arrival to justify harsh measures. We We all know what they are. C-31. Designated irregular migrants, if they're designated as an irregular movement, mandatory detention for 1 year. Oh, now they've changed it. They're going to give you a detention review after 2 weeks, which is a sham because, of course, the government, all they have to do is say, we don't know who this person is, and that detention will be continued, and then review after 6 months of it, as opposed to a year now. But the other measures, the denial of a right to apply for permanent residence, the denial of a travel document. I mean, for my clients, how many clients do I have in my office every week who are accepted as refugees, who are crying because they cannot affect family reunification? And it's bad enough now, you know, once you're accepted, you apply, you can wait, it takes 2-3 years for your case to be processed, and then you can, sometimes they'll do simultaneous process, sometimes you then have to sponsor. But now these claimants are going to be told, you can't get your permanent residence for 5 years, and then you can apply, you know, undoubtedly it'll take a few more years, and only after all of that will you be able to see your families and apply for them. And in the interim, we're not going to allow you to get a travel document so you can go to some third country where you might be able to see them. And these are measures that are supposedly to deter smugglers. What they really are measures to punish the refugees. And what they will undoubtedly do is they will create serious mental health issues for many of the claimants. So, I've given you this history of my 30 years of experience. I've sort of skipped over a lot of it. But I think I'd like to try and conclude by positing a few things. First of all, I would like to suggest that today is just one point in a long historical process. But we see several constants. First of all, I should say that one of the constants that is that the government has always been reluctant, in the sense that it's always felt that asylum is not something that they want to encourage. They don't like spontaneous refugee claims. They never did. They find them a bother, the expense of processing the claims. And they also find that it sort of prevents them from controlling the immigration flows in the orderly manner that they believe they can. So, what Ralph Gerard said in 1988, that, you know, Canada isn't a country of asylum, we're hearing the same thing today from Jason Kenney. Because basically Jason Kenney is saying all the refugee claimants are bogus, and the real refugees are the refugees who apply in the refugee camps. So that's a constant. The second constant is that the government continuously ignores the warnings of those of us who have been working with the refugees. And they do so at their peril. In 1976, we told them the system that they were proposing wouldn't work. We told them it would take too long and it wasn't fair. And we were right. The backlog grew almost immediately, and the Supreme Court in 1985 rendered the same decision. In 1989, we told them that the credible basis process was a waste of time and money and wouldn't work. And we were right. The government scrapped the credible basis process in the 1990s. And today, we tell them again, mandatory detention won't work. It's not going to achieve your objective. It's not going to discourage refugees. Refugees will still come. They'll come because they have no other choice. And mandatory detention is unconstitutional. Punishing refugees won't work. It's not going to discourage genuine refugees. They'll still come. Many of them won't know that these provisions are in place until they get here. And once they get here, it'll be too late, and they'll still make their claims, and they'll be accepted. And by punishing the refugees, all that we're doing is creating other problems for our society. Mental health issues, humanitarian issues that we're going to have to deal with for many years afterwards. Arguably, and certainly we will argue forcefully before the courts that these provisions are unconstitutional. The third constant is that the courts push back. We live in a society where there is still the rule of law, and there is always this constant dialogue between the executive and legislature and the courts. And when the executive goes too far, the courts will push back. We saw it in Charkawi 1, we saw it in Charkawi 2, we saw it in Qatar, we saw it in Abdul Razak, and I'm certain we're going to see it in decisions of the courts. I expect to see it in Ezekola, I expect to see it in Agrera. I expect that the courts will push back against the unreasonable positions taken by this government. And the fourth constant is the commitment of hundreds and even thousands of people who continue to work to protect refugees. After the government was elected, and we knew, based on their rhetoric during the campaign, that we were in for a difficult moment, lawyers and academics got together and we formed the Canadian Association of Refugee Lawyers. The organization's only been in existence for less than a year now, and yet in that time we've done a great deal of work trying to assert a presence, to speak out, and to defend the rights of refugees. But CARL is just one group. There's the CCR. There are countless other individuals who are committed and will continue to be committed to work and to defend the rights of refugees. And then, of course, there's the refugees themselves. Anyone who works with refugees and who hears their stories always feels compassion. And that's one thing that we have to always remember. The stories of the refugees are stories that have to be told. Seen from this perspective, today, in this period of time, is but one moment, and it too will pass. 10 years from now, Jason Kenney will be but a footnote. One can always hope, and indeed I'm confident the day will come when there will no longer be a need for people to seek asylum. But until that day comes, there are many of us here in this room and around the world who are committed to the protection of refugees and to the rule of law. And we will all work together to ensure that Canada will continue to welcome and protect refugees. Thank you very much.